When a parent passes, everyone says, "Don't worry, there's a trust." But then someone else mentions a will. That silence that follows, it isn't just awkward. In California probate, it's often the first sign that the rules of the game are about to change. People use these words interchangeably. But if you're being left out of the loop while decisions are being made, you need to know that wills and trust are not the same thing. Depending on which one you're actually dealing with, the legal process changes, the transparency changes, and most importantly, your ability to get answers changes. So if something feels off, it might be because you're looking for a will based answer in a trust based world. Today, we're going to look at the visibility of a will versus the silence of a trust. So you can stop guessing and start understanding exactly what you're dealing with. Before we go any further, my name is Angelique. I'm not a lawyer. I'm an educator who represented myself in California Probate Court. This video is for educational purposes only, not legal advice. My goal is to help you understand the process so you can better understand questions and figure out your next step. Most videos focus on how to plan an estate, but this video is for those who are already in one and realize they don't have the full picture. Think of it this way. In California, the law handles a will and a trust through two completely different procedural systems. If you don't know which one you're dealing with, you're essentially operating without a map. This matters because the specific document dictates your rights. It determines which records you can legally demand, who is actually in charge, and most importantly, the strict timelines the law sets for you to protect your interest. Whether it's a will or a trust affects every move you make. And if you're looking at the wrong set of rules, you're losing time. And in probate, time is a commodity you can't afford to waste. So let's start with the will. A will usually comes into play after someone passes away, but nothing really happens with it until it's brought into court. That usually means someone files a petition to start the probate process. Once that happens, the court gets involved and there's a structure to follow. There's a timeline. People who are affected are usually notified. And from that point on, the process becomes more visible and more predictable. The person in charge, often called the executor, gathers what's there, pays what needs to be paid, and distributes what's left according to the will. Think of a will as a public paper trail. Once it hits probate court, the law is designed to shine a light on that trail. The executor is on the clock, and they are legally required to show you the progress. Now, trust works differently. Unlike a will, which takes effect only after someone passes, a trust can take effect while they're still alive. If a loved one is unable to manage their affairs, the successor trustee can step in. In my case, the trustee had actually taken over about 7 years before my mom passed away, and we didn't even know it at the time. So, unlike a will, where something has to be filed in the court to get things started, a trust is handled privately. Because of that, you may not automatically see what's happening or receive court notices. A lot of the time, you're relying on someone else to share that information with you. Now, to be fair, trusts are designed this way on purpose. They're built to avoid delays and to stay more private, often by avoiding court altogether. And for a lot of families, that works exactly as intended. But that same privacy can create a black box effect. Because it's private, a trustee can manage assets for years without a judge ever seeing the books. In that situation, silence can sometimes be a strategic choice rather than an oversight. And that's where things start to feel off. Because it's not just, what is this? It becomes, what's going on? And why don't I know anything? With the will, the process is usually more visible. With a trust, things may be happening, just not in front of you. So, whether you're dealing with a will or a trust, when something feels off like this, it's usually not random. It tends to show up in patterns. Maybe things suddenly change near the end. Maybe one person received everything, or you received less than you expected. Maybe you're not getting information, or what's written in the document doesn't match what you were told for years. In the legal world, these aren't just accidents. they can be indicators of a larger issue. A sudden change near the end might be a sign of undue influence. Being told there's no information isn't just frustrating, it could be a breach of the trustee's duty to keep you informed, which is why, before you decide what to do next, you have to understand what you're actually dealing with. Because once you understand the document, you start to understand the process, what's supposed to happen, and what to expect. Otherwise, you end up asking the wrong questions. And in probate, the first question isn't, is this fair? The real question is, do I have the legal standing to challenge this in the first place? In my next video, I'll go into more detail about the specific areas where things can go wrong, whether you're dealing with a will or a trust. But before you go down that path, there is a fundamental step you cannot skip. You need to determine whether you actually have standing to challenge the situation in the first place. Without that, even the most obvious red flag might not be something the court can address. So here's the key takeaway. When something feels off, you have to look at the structure. With a will, you're usually dealing with a process you can see, a public court proceeding. With a trust, things may already be in motion and not always visible from the outside. And when something doesn't feel right, people's first reaction is to ask, is this fair? But it's important to understand that in probate, fairness isn't a legal standard. The court rules on standing. Think of standing as your entrance ticket into the courtroom. If the law doesn't recognize you as the right person at the right time for the right reason, the judge won't be able to hear your case. Once you verify that you have the right to be there, everything changes. You can see what's supposed to happen. You can determine whether the rules are being followed, and you can identify your next step. Because in probate, the first question isn't, is this right? It's, do I have standing to even challenge this? Instead of trying to figure out these complex rules on your own, I've distilled the core requirements of the California Probate Code into a 60-second standing quiz. It's designed to help you determine if you meet the right time, right person, right reason criteria that I've discussed today. It's a simple way to get clarity on your legal standing before you spend time or resources on a formal consultation. You can find the link to the quiz and receive a free evidence checklist in the description below.